Okay, good morning, everyone. I think we'll go ahead and get started. I know you're all eager to hear everything that's going to go on in this morning's session. I'm Rhoda Whitaker-Kriz. On behalf of TRIAD and the SALT Council, I welcome each of you this morning. And we're very happy to have our Westminster Canterbury friends who are joining us on their TV sets this morning. And also a thank you to Westminster Canterbury for this lovely, the use of this room and the most welcome breakfast that they are providing for us this morning. This morning's workshop is the third in a session, in a group that we've been having. As you see, well, it was on the screen. The first one was on advanced medical directives, and the second one was on power of attorney. How many of you is this the first time that you've come to one of these? Okay, so most of you have been with us before. And we are presenting these to try to help people to learn more about the things that you need to plan for after you become a senior. The TRIAD is an organization. It's not an acronym. TRIAD is a word that means a group of three. And in this case, it's the law enforcement and the agencies and organizations who serve the seniors and seniors themselves. To carry out the work of the TRIAD, we have the SALT Council, which is seniors and law enforcement together. And it is made up of the Winchester Police, Winchester Sheriff, Frederick County Sheriff, all the agencies and organizations that serve the seniors. And George, my husband George, and I represent the seniors of Winchester and Frederick County as the lay people on the SALT Council. The first two sessions that we had are now available online if you would like to see them. And what you need to do is go to the website winchesterpolice.org and click on Community, and then Winchester Frederick County TRIAD. And there you'll be able to access the other two seminars. And this one will also be there after the session. This is very informal this morning. Please feel free to go visit the food, coffee anytime that you wish, and please feel free to ask questions. If we have complicated, personal, detailed questions, we might hold those until the end and talk with the appropriate representative. But if it's just generalized questions, we'll be glad to take those during the session. At this time, I'd like to ask Stephanie Landis from Westminster Canterbury to come up and just give us a few housekeeping, and then Josh Hummer will take over for the rest of the program.
Good morning, Rhoda. Good morning, everyone. Thank you so much for coming today. We're so happy to have you here on our campus. As she mentioned, my name is Stephanie Landis, and I'm the Director of Development and Community Relations, and it really is our privilege to host you here this morning. Just a couple quick things before we get started. First, if you will take out your cell phone and either put it on silent or turn it off, that will help limit some of the distractions today. Also, if you do need to excuse yourself to go to the restroom, feel free to go out these double doors. The restrooms are right on your left. So as she mentioned, this is very casual today, so feel free to excuse yourself as needed. And then lastly, I think, is there anything else I need to mention? Oh, we have a couple handouts left over from some of our earlier presentations. Some of them include our File for Life, which is a wonderful packet to put on your fridge to keep everything consolidated and easy access, and some other tools as you start your long-range planning to use for discussion purposes. So again, welcome. Thank you for excusing our construction mess. We're happy to have you here, and feel free to raise your hands if you have any questions. We are recording today's session, so if you do have a question, I ask that you wait till the microphone gets to you to make sure it will be heard for those that are watching at home and for those that watch the recording at a later date. Thank you so much.
Thank you, Stephanie. One more little thing before Josh comes up. You have pads of paper in front of you. If you think of something that you would like to hear presented in the future, some topic that you would like to have information about, please jot it down, give it to me or to someone with the SALT Council after the meeting. Thank you.
forgot my clicker. Good morning. For those of you who haven't been here, and I realize that's just a few, my name is Josh Hummer. I'm an attorney in town with the law firm of Lawson & Silik. We're, I guess, a local law firm. We have offices here in Winchester, and then we also have an office down in Front Royal. We do a fair amount of estate planning, actually a large amount of estate planning and elder care law, and that's why I've been asked to, thank you. Can you all hear me? Can everybody hear me? Is that good? By the way, thank you to whoever came up with this. Last time, I don't know if you saw me, I was shaking and trying to hold the mic, so this is wonderful. I've been asked today to speak about wills, and as Rhoda mentioned, this is the third in our series of 3 on estate planning issues. I think it's taking control of your end-of-life care. And I've actually broadened it just a little bit. We're going to talk about wills, and I'm also going to talk about estate plans. The purpose of this, and I always have to give this disclaimer, is not for me to be your attorney. This is just general information. I do represent many people, but this is general information that we're providing. The format we've used in the past, and I'm going to try to stick to it for this presentation as well, is what is a will? Why do you need it? And how do you get it? Okay? What is a will? Why do you need it? And how do you get it? Starting out with what it is. This is the official Virginia State Bar definition of a will. A will is a written, signed document in which an individual, known as a testator, states directions for the distribution of assets at death. The will appoints an executor who is responsible for administering the assets upon the testator's death. Everybody get it? We can all go home. I can sit down. You all can eat. We good? Let me see if I can unpack this just a little bit here. Practically, a will is a legal document. Now, don't get exacerbated with me just yet. A legal document, it means 2 things with regard to a will. One is it's enforceable. And this is a good thing, right? If you go to all the trouble to spell out what you want to happen with your assets, you want it to be enforceable. You don't want somebody to be able to disregard it. And because of this, because a will is a legal document, it means, if necessary, a judge will actually require that what you put in that will be done. Now, there are all sorts of caveats and requirements and conditions, but if you fulfill all those, it is an enforceable document. The other benefit, or the other side to it being a legal document, is that there are all sorts of requirements. It wouldn't be a legal document if there wasn't some red tape, right? So, the same is true of a will. There are requirements as to what you can put in a will. There are requirements as to what state of mind you must be when you sign a will. There are requirements as to how you sign a will. There are requirements to what you must do with a will after somebody passes. There are all sorts of requirements and conditions, and this tends to frustrate a lot of people. I can't tell you how many times somebody comes into my office and they are just annoyed with the whole process. They think, it's my money. I should be able to do whatever I want to with it, and it should be easy. And I always tell them, and I'll suggest to you all, that that's a little missing the point. And the rules and regs, and we have the clerk of Winchester City Circuit Court here with us today, and he'll talk a little bit about this. I don't know, maybe he will. But the rules that we have put in place, the requirements for wills, whether it's what you can put in them, how they have to be signed, or what has to be done with them after somebody dies, they all are intended to help us ensure that what somebody wanted is really being done. And let me see if I can make this a little bit simpler. When you write a letter, and you write something, you say you write something to your friend, and you write them a letter, and it's, dear so-and-so, and you put something in there that they're not really quite sure what it means. They can ask you. They can call you on the phone. And the problem with a will is that, by its very nature, we can no longer go back and confirm what this person really wanted to do. So if the will isn't clear, if the will is ambiguous, then it becomes a problem for the court system. And we want to make sure we get it right. This is a person's last chance to speak. And so we want to honor that. And so we've come up with a number of these rules and a number of these requirements. And this is why the system is so complex, is that we want to make sure we are honoring what someone has done as their last chance to speak. So a will is a legal document. It gives directions for how to transfer certain of your assets when you pass. So basically, it's an instruction manual for what to do with somebody's stuff. A will is somebody's instruction manual for what to do with their assets. And it must be submitted and accepted as part of the probate process after you pass. You saw the earlier definition referred to an executor and a testator. All that means is that when you pass, what you do is you take your will to the local clerk's office and you hand it to them, and there is a process you go through called probate. And it's not a very simple process. It's not extremely complicated either, but there is a process you must go through with your will or with someone's will after they pass, and it's called probate. The point of this is not to get into that. We don't, for our purposes today, I just want you to be aware of it and understand that it does exist. And that's the reason for a lot of the requirements and details that go along with wills, is to make sure you set it up so it goes through probate, and it goes through it quickly and without any problems. And then finally, a will, and I mentioned this before, it is someone's final chance to speak. Up until someone dies, for the most part, they are able to do what they want with their assets. However, after they pass, obviously, that's no longer available to them. And a will gives them a final opportunity, a way to set a legacy, if you will, of saying, this is what I want done with my assets, and this is how I want them handled. And it doesn't have to be as simple as, I want John to get $10, I want Matt to get 20, and I want Bobby to get 15. There can be conditions placed on them. There can be things set up, ongoing trust or other devices set up to encourage people to treat the money correctly and to encourage people to do certain things. So that's the practical what a will is. And I'm intentionally going at a high level here because getting down into the weeds, you all would get bored very quickly, and this session would take a very long time. But the other point I want to make here about what a will is that it should be part of a larger estate plan. How many people understand what an estate is? Yeah, a few. And an estate is a collection of assets of someone. That's basically all it means. So when someone passes, we look at everything they owned and we say that is their estate. That's what they have left behind. And so when we talk about an estate plan, it's a plan for what's going to happen to someone's estate. In other words, another way of saying it could be a plan for what's going to happen to somebody's assets after they pass. And this is key, and this is why I've referred to this session as about wills or estate plans. A will is just one tool. There are many other tools, and we'll talk about those in just a second. But a will is just one tool. And a good estate plan, a good plan for what's going to happen to somebody's assets after they pass, will include several, maybe even many of these tools. Other tools are trust. These are a popular one. I got asked a question in one of the previous sessions about payable on death accounts, transfer on death accounts, survivorship accounts, property held with the right of survivorship, and there are many others, life insurance and others. And so there are all these different methods, all these different tools to take someone's assets and transfer it when they pass. And unfortunately, I went too far. Unfortunately, or fortunately, depending on how you look at it, each of these tools applies to different assets, and it has different requirements, and it can be used to affect different things. So a proper estate plan, or a good estate plan, takes some or all of these tools and applies them to someone's assets in a way that minimizes expenses, minimizes taxes, and efficiently distributes their assets as they wish. And we talk about wills generally because wills are the primary tool that most people think of when they think of estate planning, when they think of passing assets on. Most people think of wills. But in reality, most people are by nature or by necessity using other tools than just wills. And so that's why I'm talking about an estate plan as something we encourage everybody to do. Let me just pause here. I'm going to be perfectly honest with you all today. My goal here, and our goal throughout this entire 3 sessions, is twofold. It's to encourage all of you and for all of your loved ones to have an estate plan that includes a will, to have a power of attorney, and to have an advanced medical directive. When somebody comes in to see me and they are looking to get a will or an estate plan or something, I always recommend they get all 3 of these: an advanced medical directive, a power of attorney, and an estate plan that almost certainly includes a will. So that's the first goal. The second goal is to give you a little bit more information about all of these so you know what you're talking about when you do go seek an attorney or when you're reviewing your own assets or your estate plan. So you have enough knowledge to be dangerous. Let me put it that way. So that's what a will is. Before I move on, are there any questions? Yes, ma'am. Just hold on a second. We got to wait for the microphone.
Okay, what's the difference between a living will, or what does a living will has that the regular will doesn't have, and vice versa?
Sure. That's a great question, and we touched on this a little bit in the presentation about advanced medical directives. A living will is not a will. They're completely different things. A will, as we've just talked about, discusses how assets are transferred after somebody passes. A living will puts into place or sets requirements for what type of medical treatment someone wants while they're alive. And actually, the term living will isn't really used frequently in Virginia anymore. It's really an advanced medical directive. And an advanced medical directive includes both what used to be living will, which is what type of medical treatment does somebody want, and then also who do they want making their medical decisions for them if they're unable to make them for themselves. That's also called a medical power of attorney. So it's a great question. They're 2 separate things. Living will, medical treatment before you pass. Will, what happens to your assets after you pass. Does that make sense? Okay. Any other questions before I move on? All right. Why do you need a will or an estate plan? I'm sure some of this will be obvious to most of you, but the sad fact is that a majority of people in the United States do not have a will or an estate plan. And you may think, well, certainly most sophisticated, educated people have wills or estate plans. No. Certainly most attorneys have wills or estate plans. No. The numbers are shocking. That most people do not have a will or estate plan. Even folks who should know better, even estate planning attorneys who should know better, for one reason or another, don't go through the process of getting one. The first reason is, and you all probably guessed this, to ensure that your assets are distributed as you want. And this is not always clear. Many people who I talk to will say, well, if I die, won't my kids get all my stuff anyway? And the answer is maybe. There is a process in Virginia called intestacy, by which if somebody dies without a will, their assets get distributed according to a bunch of statutes. And it normally goes with who's closest in relation to the person when they die. But it's not simple. And there are lots of rules, and we generally find, or almost always find, that people don't want those rules. They may think they're okay, but once we explain them to them, then there's always something that they don't like. And we had a case recently that went up before the Virginia Supreme Court where a lady who had passed had a niece that she was very close to. It was her closest relative. And she told she assumed, under the laws of intestacy, that the niece would get everything. I think it was several $100,000 in this lady's estate. There was only one problem. The niece, as an adult, had been adopted by another relative. And I don't know if you all remember this. About 10 or 20 years ago, there was a movement going on whereby people were getting adopted as adults because they thought it would help them take care of them. And it never was, I think, recommended by the legal community, but a lot of people were doing it. They thought, I can help my aunt so-and-so out if I'm adopted as her daughter, it makes it easier for me to make decisions for her. It wasn't a good idea, but a lot of people were doing it. And that's what the niece did in this case. She was trying to help another relative out. Well, under the laws of intestacy and adoption changes everything. And that law generally makes sense when you're adopting a child. When you're getting adopted as an adult, it doesn't. So this lady, this aunt who passed, intended for her niece to get everything, but her niece got adopted, and it turned out her niece got nothing. And the reason was, if she would have put together a will and said, I want my niece, named whatever her name was, to get all of my stuff, it would have been very clear. But as it turned out, she had some second cousins who, once they found out that she died, they came out of the woodwork, which you won't be surprised to hear that happens frequently, and paid an attorney a lot of money to fight this niece for her aunt's estate. So that's just one example. There are many examples, and there are many rules like that have an unexpected result. And if you simply rely on what's in the statute, you can often get into trouble. The next reason you need a will is to avoid paying unnecessary taxes. Quick quiz. Everybody likes quizzes, right? Especially pop quizzes. My wife is a teacher, so she loves giving her students pop quizzes. What is the tax rate? What is the federal tax rate on estates? Anybody guessing? How many here think it's 15%? 20%? 37%? 45%? 55%? It's 55%. Now, it's not quite that bad because there is a exemption for the first certain amount of an estate. And over the past 10 years, that exemption has ranged anywhere from $300,000 up to where it is at $5 million. So right now, there's a $5 million exemption on taxes. So the first $5 million of your estate, you don't have to pay taxes on. But we don't know how long it's going to stay that way. It was down at $300,000 about 10 years ago. And there are always rumblings in Congress about decreasing it because they're always looking to generate more income. And there is the feeling, right or wrong, that this is an easy way to generate income is to raise the estate tax. Yes, ma'am. Hold on just a second. I see two questions.
What about state taxes?
Right. Great question. There are state taxes as well, state estate taxes, and they vary from state to state. In Virginia, they're fairly small. I don't know the exact amount, but as a general rule, we're not concerned about those when people have assets in Virginia. However, and in fact, for Virginia, they're part of the probate process. So when you go through the probate process, when you probate your will, you have to pay some percentage. And Terry may know what the exact amount is. I don't. I can tell you when we look at it, it's a de minimis number. It's nothing compared to the federal taxes. However, other states are different. Take, for example, Pennsylvania, I believe, is at 7 or 8%. And that is, and so if you have assets in other states, you do have to look at that. For example, let's say you own land in Pennsylvania. You would need to be aware of that and look for ways to avoid paying that state tax. I think there's one other hand. Yes, ma'am. Just hold on just a second. She's coming. Oh, that was your question too. Okay. So, avoid paying unnecessary taxes. The good news is that the IRS tax code is incredibly complicated and has many loopholes. So there are ways around it. There are gifting schemes you can do. There are ways you can have, you can get your assets out of your estate for treating them for tax purposes. None of them are easy, but all of them are better than paying the government over half of your estate. So one key reason to have a will or an estate plan is to avoid paying unnecessary taxes. And I have to tell you, we see this again and again. Somebody who should have known better, an attorney with the largest estate, will end up paying millions of dollars in estate taxes. And all because they didn't bother to sit down and come up with an estate plan and put a will together. The last one is, in my opinion, probably the worst. And honestly, folks, this is where I get a lot of my business. When somebody passes with either without an estate plan or with one that's not clear, I mentioned before, relatives come out of the woodworks. We had one recently, a 92-year-old lady. Her husband passed, and her husband's siblings, who they hadn't spoken to for 20 or 30 years, called immediately after the funeral, started asking how much money they had and when they were going to get their cut. And money does funny things to people, right? I mean, you've all seen this. And when there's a pot of money there that somebody thinks they have a chance at, they're willing to do all sorts of stuff, including hire an attorney to try and go after it. And the sad thing, and in my opinion the worst part, is that in almost every instance, the person who passed wouldn't have wanted this. In fact, it would have probably been the worst thing. In many instances, I think they would have rather just given the money away or just lost it or given it to the government than have their family split up as a result of trying to fight over what they had. But again, this happens all the time, and this is something that I see a lot because people come to me in these situations and they pay me, quite frankly, a lot more than they would have paid if they would have simply done the estate plan at the beginning. All right, so that's why you need it. So we've covered what a will is and why you need one. And the third part of the presentation, the third point today, is how do you get it? You go see an estate planning attorney. This may seem a little bit self-serving on my part, but this is one thing that I cannot stress strongly enough. You can use forms, and we'll talk about those in a second, and we'll talk about the problems with those. But if you want a customized plan, and let me even back up. A will is a legal document, so you are by law allowed to draft one yourself, or you have to have an attorney do it. You can't go to somebody else. You can download forms off the internet, but to get somebody to craft one for you, you have to go and see an attorney. It's doing it, paying some other person to do it is called the unauthorized practice of law, and it's illegal. But getting somebody who is experienced in these things is a necessity, and the reason is because of what we've already talked about. Because of the complicated requirements, not only in having it executed properly, but in also applying it to your assets and applying it to what you want to do with those. And then let me also put in here, you see it says estate planning. There are many different types of attorneys. There are attorneys who specialize in criminal law. There are attorneys who specialize in domestic relations, divorces, commercial law. And then there are attorneys who specialize in estate planning. And unfortunately, many attorneys who do other types of law think of estate planning as easy. They think of it as something they can do on the side, and if you ask them, could you do a will for me, many of them will say yes. And so we'll get to my tips later. But one of the things you need to be on the lookout for is when you're choosing an attorney is, do they do this type of thing? Have they done it before? How often have they done it? And what type of estates have they handled? Someone who's done a quick will for a couple $20,000 estates is not going to have the expertise, most likely, to handle a much larger estate with tax implications. So, estate planning attorney. Let's talk about forms. How many of you have heard that you can go online and download a form for a will? People heard that? Yes. It's pretty common now. You'll see advertisements for LegalZoom and some of the other ones. The problem with forms is that they are a one-size-fits-all solution. They are intended for somebody else, for their estate plan. And and it doesn't take into account that everyone's estate plan is unique. It is not the same as your neighbor, just because your neighbor has different assets and has different desires. Another problem we're seeing with forms is that they don't meet Virginia law. I had a friend of mine call me up last week, like many people do. He was about to go on a trip, and he wanted a will. The only problem was he called me the day before he was going on his trip. And I said, I'm sorry, I actually had to be down in Roanoke the next day. I just couldn't make it. And he said, okay. And he said, I'll see you when I get back. Well, about an hour later, he called me back. He said, hey, it's so okay. I found this great form online. I downloaded it. It says all I have to do is come in and have you notarize it. And I said, well, hold on. I can tell you right now, that's not going to be any good. Because under Virginia law, a will needs to be witnessed by two people. And there are a few exceptions, but almost all the time it needs to be witnessed by two people. Well, this form he had downloaded didn't tell him to do that. He was simply going to go have it notarized and think he was good to go. But in reality, it wouldn't have worked. When he passed and someone tried to take that will and get it probated, it wouldn't have been accepted. Another problem we've seen with these forms, and this happened to me about a year ago, I had a couple come in to see me, and they had done forms in the past a couple years ago, and they had a couple of young children. And each of their forms, they each had two identical form wills, and each form provided that all of their assets went to their kids in equal amounts. And some of you may have already picked up on the problem here. The first one to die was going to be left with only half. Now, how almost everybody sets these up is so when the first person to die, everything goes to the surviving spouse, and then the surviving spouse, when they die, it goes to the kids. Well, if these folks would have died, half of whatever that first person owned, and if it would have been the husband, almost everything was in his name, would have gone to the kids. The wife would have been left with nothing. But just pulling off the form, they hadn't thought to consider that. And the form, whoever drafted the form, obviously hadn't thought that this would be used by someone who was married. So that's the some of the problems with forms. There are others that we've seen. If you have any size estate at all, it's almost certainly, your estate plan is almost certainly going to involve a collaboration with other experts. You're going to need an estate planning attorney, your accountant may be involved, your financial advisor may be involved, and it may well depend on the different tools that are in your estate plan. If you have certain accounts that pass or payable on death, whatever the organization is that holds those accounts will need to be involved as well, and we certainly recommend that. All right, so that's how to get a will or how to get an estate plan. I want to leave you, as I have with each of the past two sessions, with a couple of tips. And some of these I've touched on already, but I'll just run through them quickly. The first is use an experienced estate planning attorney. We already talked about this briefly. The second is make sure you include all of your assets in your estate plan. Folks, this happens to me all the time. Somebody comes in to see me, and I ask them what assets they have. We go through it. And 2 weeks later, I get a phone call. I forgot to tell you about this. And most of the time, it's not a problem. But what does cause problems is when somebody calls me after we've done the will and the estate plan for them and say, I forgot I have this life insurance policy, or I forgot I'm jointly own this property over here. So when you sit down and you are going through the estate planning process, make sure you include everything. How it all fits together is very important, and you can often end up with unintended consequences as far as leaving something out. There can be tax consequences, and it could also be that what you're trying to do as far as what percentage of your assets you want to go to who can be affected if you have, say, a life insurance policy that names someone and you forget about that. They may end up getting more money than you intended for them to get. This one's not going to surprise you if you've been to any of the other previous sessions. Choose your executor carefully. Just like you choose your your agent and your advanced medical directive carefully, just like you choose your agent and your power of attorney carefully. You want to choose your executor carefully. Executors are bound by the will, but there are certainly certain areas where there is a lot of flexibility. And so you want to be sure it's someone who you trust. And then the other thing is you want to be sure who it's someone who you've talked to. They are willing to do it. We have this problem, again, on a fairly regular basis. Somebody passes, we get a will, it names John Smith as the executor. I call John Smith, and he says, no, I'm not doing that. Either one, he doesn't want to, or two, it's too hard, or three, there's some other intervening issue. So make sure they're willing to do it before you put their name down. And then the third part is discuss it with them. Tell them what you want to do. As I said, there is a fair amount of flexibility for the executor. And so make sure they know the spirit of what you're trying to accomplish, so that if something comes up, if something changes, if something unexpected happens, they have a good idea of how you would want that handled. And the final one is have your will/estate plan reviewed as your estate plan changes. And this is just something to be aware of. We often see people come in with 20 or 30-year-old wills that were 1 or 2 marriages ago, a completely different financial situation, completely different child situation. Often see them name 2 children and don't name the third. That's been was born after the first will was made. So keep in mind, when you're going through a major life event, think about, does this require a change in my estate plan? And if you think it could possibly require one, it's a great opportunity to go back and talk to your attorney or your group of advisors and say, hey, is this something we need to deal with now? Do I need to change this? And then also, if you hear about changes in the law, it's hopefully your attorney will contact you if something major happens, like the tax exemption goes from $5 million down to $500,000. Hopefully you will get a call. But if you hear about something like that, it's another good opportunity to call up your attorney or call up your advisors and say, hey, I just read about this. Does this affect me? Does this affect my estate plan? So those are the four tips. And before I close, I do want to give an opportunity for questions, and I see we have one back there. Yes, ma'am.
Would you talk a little bit about how to choose an executor, whether it be a family member or a friend or a banker or what?
Sure.
Just a short overview of it.
What we tell people, and it really depends on your personal circumstances, but we tell people to try to find somebody who's going to have the ability to do it, the willingness to do it, and then also they're going to have an incentive to do it. So you can always pay somebody, a banker or a trust department at a bank to do it, but they're going to charge you. And sometimes it's a percentage of the estate, sometimes it's a flat fee, but they're going to charge you. What we recommend instead of that, in most cases, and it's a case-by-case thing, but in most cases, we suggest you find somebody who's getting a large portion of the assets, and if they are willing, make them an executor. And obviously they have to be trustworthy too, but they have an incentive to want to handle the estate correctly and get it done because they're getting money from it. So that's our recommendation. If you don't have anybody like that, you can certainly look at a trust department at a bank. They will do it, but again, they're going to charge you, and it doesn't make a whole lot of sense. If there's somebody else who's actually going to get the money, who's willing to do it, why not let them do it and save the extra money? Does that make sense? Save the amount that would have been paid to the trust account or the bank.
What happens when your executor dies before you do?
Yeah. They can no longer be the executor.
Well, I know that.
When they die, if you have a successor or an alternate executor named in your will, that person can step up and do it. And so we do recommend, if possible, people have an alternate or a backup.
Yeah, that was my question.
And if both of them die, then anyone, and there's a certain the statute, and it's fairly complicated, but in certain time periods, various people can step up and be the executor. But then, if there's not somebody named in your will, someone else has to step up. There are often problems when that happens. Oftentimes they have to be bonded, and there's some other issues that come into play. So that's why we encourage people to have not only one but also two. But that's a great point. If your executor dies, it's probably time to take a look at your estate plan again and find somebody else to be your executor. And again, this happens on a fairly regular basis. The executor, we get a will, the executor died 20 years before this person died, but they never bothered to actually go in and change the will to name somebody else as an executor. So great question. Yes, ma'am. Hold on just a second. I'm sorry. Hold on just a second.
Is it true that in the state of Virginia, you cannot settle a estate for at least a year? Is that a law?
There are a number of laws, and there are time periods that are involved sometimes, but it depends on the type of estate. And so it will depend on what you have in your estate, what type of property you have in your estate. But no, that is not the law for all estates. No, ma'am. Yes, ma'am.
I'm a bit confused. An estate plan, oh, thank you. An estate plan has a will in it, or is it the same document?
It is not the same
document. Is it two
document.
different documents?
An estate plan is not a document. An estate plan is a plan. It is a strategy. It is a collection of tools that will probably include a will, but may also include a trust, may include certain payable on death accounts or other methods of transferring assets. So an estate plan is a strategy, a plan that you and your advisors come up with to make sure all of your assets get from you when you pass to where you want them to go. A will can be used as part, and is almost always used as part of that estate plan. But it is not the same thing. An estate plan is broader, and a will is simply one of the many tools that an estate plan will use. Does that clarify things?
So the estate plan have to be legalized?
It does not. An estate plan is not a legal document. It does not even have to be written down. It probably will be recorded somehow so you know what the plan is. But it is simply a strategy. A plan is the best way I can do it. And it can be written down. It can be verbal. But this is how all of these assets are going to work when I pass. This one's going to go with the will, and it's going to go here. This one's in a payable on death account, so it's going to this person here. This one is going to be is deeded with the right of survivorship, this real property. So it's looking, when we say a plan, it's the overarching view of all of these things, all of these different assets, and how each one of them gets where you want it to go when you pass.
Thank you.
Sure. Yes, you've already got a mic. Yes, ma'am.
So things like IRAs and 401ks and life insurance policies where you're asked to name a beneficiary are not necessarily addressed in a will. Those things are already allocated. Is that correct?
Yes, and again, it depends on the specific account, but most of those pass outside of a will. They go directly, so there are other tools. So yes, if you have an IRA that has a beneficiary designated on it, then when you pass, assuming you've set it up appropriately and that beneficiary is still living, the IRA, the company that holds the IRA, will pay it directly to the beneficiary. But it still needs to be considered as part of the estate plan for tax purposes and for also just deciding who gets what purposes. But yes, those are not used by the will. Yes, sir.
What are your views on having co-executors or co-trustees?
It really depends on the exact circumstances. You sometimes need it in Virginia if you have the executor, the person that you really want to be the executor, is from out of state. It becomes more difficult if they're out of state, and we often, because of bond issues and other issues, and it may even be a requirement under the law, require them to have somebody who is a resident of Virginia as a co-executor. But it could also be if you simply don't trust someone and you want two people there looking at everything. That would be another reason. But it normally depends on that. I don't always recommend it. If somebody has someone that they trust and that they have a clear will and a clear estate plan, I don't think it's necessary.
Josh,
Yes, ma'am.
if you're single when you die,
Yes, ma'am.
if there is a will and you've specified just your children, or if there's no will and there's an ex-spouse, whether you are separated or divorced, what happens then? Who has to be named, and what claim do people have if they're not named?
I'm not sure I follow the
Okay,
hypothetical.
all right. If you're single when you die
All right.
and you have a will,
And
well,
have-
let's say first that you have a will.
we're
but
doing
you-
multiple
Yeah,
hypotheticals.
we're doing
All right.
two hypotheses.
All right.
Okay, if you have a will and you've left everything to your children,
Okay.
but there's an ex-spouse who may or may not have remarried, does that ex-spouse have any claim to anything in that will?
Assuming if the will does not name the ex-spouse.
Right.
no.
Okay.
Now, if the will does name the spouse, yes.
Okay.
And we see that happening. Somebody has divorced someone for 20 years, but they forgot to change the will. And there are some arguments against that, but in many times we've seen ex-spouses get money simply because someone forgot to change the will. So that was your first time.
That is the first part.
What's
Now,
what's
if
the
you
second?
die and there is no will
Okay.
and there's an ex-spouse, whether you were separated or divorced, does that ex-spouse have any right to the estate?
I don't believe so. I haven't. As I said, there's a set of statutes that govern intestacy, which means what happens to your estate when you die without a will. And I don't believe the ex-spouses, once you're divorced, I don't believe they're entitled to anything. I believe it would all go to the children, but that would be that would be something that you would want someone to look at carefully. And honestly, the best thing to do would be to get a will and specify exactly who you wanted your assets to go to.
Just one more. Everybody needs a will.
Yes, ma'am.
Even all of us probably have grandchildren. When does a person need to think about having a will?
The legal answer is everybody needs a will. Practically, we don't think children need wills unless they're at some sort of risk or have or they have more assets than you would normally expect them to have. Putting an estate plan together for a child who doesn't own anything, who we don't expect to die, it's just not something we think is a worthwhile use of funds. That being said, if you do have a terminally ill child with cancer, there often is a will put into place, and normally it's for some sort of memorial for them because they're receiving money or people are paying money to them to help with medical expenses. So that's the reason we do that. But most of the time we encourage people, once they have someone they want to take care of or they have substantial assets, and substantial isn't a lot, but once they have somebody that needs to be taken care of, or once they have substantial assets, to get a will. And one thing for younger folks, for young parents, a will allows you to designate who you want to be your child's guardian when you pass, who you want to take over. And so we often see young couples, and we recommend that young couples do a will to set up and to designate someone to care for their kids when they're gone. If you don't do that, then the decision's made by a court, and multiple people can come in and argue. Another reason for younger couples to do it, Rhoda, is so they can establish that guardian for their kids. One more. Yes, sir.
Going back to the co-executors,
Yes, sir.
If they don't live in the same jurisdiction, it can lead to problems in probate.
Yes, sir.
To open an estate account, many banks require the physical presence of both co-executors to do that.
Yes. They do, and we anticipate that at least for the beginning, and I guess what you're referring to is my comment about when you have an executor that you want but they're out of state, we often encourage them to designate a local, somebody who does live within Virginia as a co-executor. And it can be a problem. So ideally, you have an executor who lives in Virginia, who you trust, who handles everything. If that's not possible, then yes, you do the co-executor, and it does become more complicated. The bank certainly will require both of them there, and for other things, they will have to sign certain documents. Both of them will have to sign certain filings that are required to be done. So it does get more complicated when you have co-executors, and particularly when one of them isn't present locally. But for some people, that out-of-state person is the person they really trust and want, and so we try to work around that. And one way to do that is with the co-executor. Yes, ma'am.
I have two questions. One is, will you address trusts and how they work into a will? In other words, should you have a trust rather than just as part of the will? And the other question is the disposal of your body. Do you put that in the will as well? For instance, if you choose to give your body to science, how do you set that up?
Sure. First question about trust. Trusts are an incredibly flexible instrument. So you can use trust for any number of different things. Basically, a trust is the easiest way to think of it is creating an artificial entity or another person that you're giving money to. So when you say, do you need a trust to go along with your will? Maybe. It really depends on what assets you have and what you're trying to do with them. In many instances, we use trust to protect money from creditors of a particular person that we want to have the benefit of the funds, but we know they're having financial problems. You can use trust to take care of children. You can use trust to make it so your assets don't have to go through probate, which isn't as big a deal here in Virginia, but in other states like Pennsylvania, it can be very valuable. You can avoid the probate tax by having all your assets put in a trust. So there are many different uses for trust, and in many cases, yes, you would want a trust to be part of your estate plan, but it really depends on the individualized circumstances. And your second question, I believe, was about can you put in a will what you want done with your body? And the answer is yes, you can put that in there. Any more? All right. Yeah. And Terry may. And Terry, let me introduce Terry, and then I think he's going to respond to. He's going to give you some more information about one of the questions. We're really excited to have with us today Terry Whittle. He's the clerk of the Winchester Circuit Court, and he is the one. If somebody passes in the city of Winchester with a will, and you take the will in, you go see Terry, or you go see one of the staff members. And so we're really excited to have him here today to talk to us a little bit about wills and about the probate process. And I think you're going to address one of the questions that was just.
Yeah, my name's Terry Whittle. I'm clerk of the Circuit Court for the city of Winchester. One of my many duties is to be like the probate judge in Virginia. When someone dies and there's an estate, and they live in the city of Winchester or have died in the city of Winchester, they will probably come to see me to have the will put on record and possibly someone to administer the estate. Going back to your question on trust, and I'm going to constantly refer back to Josh. As a clerk, I can't practice law, but probably every day I probably give legal advice. Now, having said that, it probably could get me in trouble. I don't know. But you mentioned about trust, and one of the things that when you do a will and you sit down with an attorney that you should probably consider is the executor who's going to handle it, and make sure that person knows what you want them to do. And I'll just say there are some cases where trust does make sense. Let's say you have a son or daughter incapacitated, and you want them to be cared for their life. So you may name in the will, create a trust so that individual may be taken care of. Now, having said that, that person, whoever is going to be the trustee of that trust under the will, you might want them to know they're going to do that, because this person may live many years after you have died. And sometimes that person doesn't realize that. So they may be handling a trust for 10, 15, 20, 30 years, and it may be something they get tired of dealing with. Now, I hate to say it that way, but I've seen that happen. People have been named the trustee, and then years later they come back to court, want to be removed because it's just tired. They get tired of having to make certain filings that they have to do. But that's just something to consider. One of the things I will ask right now, and going back to what Josh said about why you do a will, how many people, just by a show of hands in here, have a will? How many, and keep your hands up, how many people have a will that was done by a lawyer? Okay, some people did not put their hands down. One of the things I do suggest in what Josh mentioned is when you do a will, make sure it's done by a lawyer. As a clerk in the last 5 years, I bet I've had to reject many wills because they were done without the advice of a lawyer. Some people in this day and age now will go to the internet, will get a will off the internet. Sometimes they're good, but if you don't do it correctly, it can cause problems. As I try to tell people, if you have a legal or if you have a medical problem, you go see a doctor. If you have a legal problem or a legal issue, you go see a lawyer. Writing a will is a legal issue. And from my experience, I always try to tell people, if you want to write a will, you don't go to Staples for your legal work. That's not your lawyer's Staples. You can get a document there that says create a will, probably save you what you think a lot of money. But lawyers love people who go to Staples because Josh is going to make twice as much cleaning up the mess that you created, and it doesn't matter. He'd much rather have you come to him beforehand than to wait and when a mess has been created. Those people who've done a will and named an executor, how many people in here have told their executor they are the executor? Make sure that the executor knows they're going to handle this will. Of that number here, make sure your executor knows where your assets are. Now, you might think, well, sure they know that. I'm going to tell them that. You'd be surprised how many people I deal with on a daily basis who come in and say, father, mother died, been named as executor, and I'm telling them what needs to be done, and they have no clue whether their father, mother, brother, spouse had $1 to their name or $1 million, and they don't know where to look. And the first thing they want to do, I went to the bank, and they told me to come see you because I need to qualify. So I'm saying, well, what's the estate? I don't know. Well, is there an estate to administer? I don't know, but I've got to start paying bills. Well, if there's no estate to administer, I don't know where you're going to get that money to pay that bill. And so if you have named an executor, make sure they know where your assets are. And this goes back to what Josh was saying was estate planning. It can be very frustrating for people to come in there to see me when they're grieving over the loss of a loved one, to have more issues arise in handling the probate or administration of their deceased or loved one's estate. Nothing worse than to have to tell someone, well, can you come back and maybe wait for a little while, check the mail to see if you get any bank statements, see if you can look around the house. There's nothing worse than to have to be dealing with the loss of a loved one, and now you're having to try to search through their personal belongings to find out what their estate is. So please, when you write a will, let the executor know that they're going to serve. let the executor know where the will is, and let them know what the assets are. One of the things that happens quite often, and you'd be surprised the number of times people have come in with a will and it's a copy. And they say, well, I don't know where the original is. Well, they checked the house, checked where. Well, Dad was a pretty private guy. He never told us too much. Well, now you got a problem. Because when you write a will, you write that document so your assets will go to the people that you want them to go to. Nothing worse than to tell someone, well, we can't admit this copy to will, or this copy of the will to a record. So we're going to have to assume your loved one died without a will. Well, Dad always wanted the money to go to, half of it to go to the SPCA and the other half to go to the church. Well, can't do that now. Well, what do I do? Well, you're stuck if you can't find that original will. And I shouldn't say you're necessarily stuck, but it could present more problems for someone to deal with after your death. One of the things everybody in here probably will agree with me is that when you die, you want your loved ones not to have to go through a lot of red tape. You don't want them to have to be burdened with trying to figure out how to close out your estate. And the one way you can do that is by going to an attorney, getting a will done, letting the executor know, hey, you're the executor, I want you to do it, I trust you, this is where my will is, and this is where my assets are. This is what you're going to have to deal with. And if you do that, you're going to be in good shape. Question?
This is just a word of advice. I worked with senior housing, rental units for independent living, and so many of the senior citizens who died alone had not given their documentation to any family member, and so the will was very often in the apartment, and when someone passes, we were required to change the locks and take possession, and we could not allow anyone in. And so even if there was a will naming an executor, now it's locked inside the apartment, and some individual would have to go to the court and get a temporary document and bring it to us before we could even unlock the unit for them to get clothing or a family Bible, let alone a will. And so a major consequence of not sharing it and giving that information, so when it happens, they have the original document in hand.
Good point. One of the things, too, if any of you have your wills in a lockbox, I don't know if any of y'all in a bank safety deposit box, if that happens, again, let your executor know where it's at. And with those lock boxes at the banks, if the deceased name is only one on it, sometimes you'll go to the bank and my mother died, will's in the, they'll say, well, you can't get access to it. Yes, you can. You can get access. They can open it up for the purpose of looking to see if a will's in there. And if the will's in there, they can give it to you so you can bring it down to the courthouse to have it recorded. But, again, these issues that you bring up are important to know. If somebody was like that, usually I would probably, if somebody came to me, I'd write a letter. I'd just type something up. Would you please allow, so-and-so access to the house? She is the daughter. She needs to check to see if there's a will in there. And we've had situations similar to that, not where that's happened, and that's worked out fine.
Would the jurisdiction where you live, where you die, have matter?
Yes, generally there's the will's going to be probated in the jurisdiction where you last resided. Now, if the deceased is in a nursing home, generally reverts back to their last known residence. Now, this is an interesting and good question here for this group. Westminster Canterbury, as I understand, part of it's in the county, part of it's in the city. And I will tell you, the clerk in the county and if somebody comes to me and said they died in Westminster Canterbury, I'm going to record the will. And I'm not going to ask, well, are you in the county or the city? Because a lot of times people don't know. And they'll come back, well, I guess it was in the city. My mail comes to Winchester, Virginia. I don't know. But I've had that, and I've probably recorded a few who lived in the county. The clerk in Frederick County probably recorded a few that lived in the city. So that's not but generally that is the first criteria, where the person last lived. Now, I will give you an example where when I first started as clerk, there used to be a big dispute about this. It was where to record the will, and you'd have these situations where some clerks would argue you had to be a resident for 6 months in the jurisdiction. Well, you'd have a situation where somebody lived in Winchester, Virginia, moved to live with their daughter in Fredericksburg, Virginia, lived there 3 months and died. So the daughter would take the will to Fredericksburg clerk, and this is not a true story, but so I'm not trying to disparage the Fredericksburg clerks. Fredericksburg clerk says, well, where'd your mom live? Well, she lived with me. She moved down here the last 3 months. Oh, got to take it back to Winchester. Comes down to Winchester. Winchester clerk says, where'd she live? Well, she lived with me in Fredericksburg. Well, you got to go to Fredericksburg. Now you have a person who's dying like a man without a country. And that would happen. There are stories. And I had one recently where an individual lived in a halfway house in Loudoun County. Prior to that, had lived in Prince William County. And came to Winchester one night and died. Only time he was ever in Winchester was the night he died. And so when he died, his father had to handle some assets of the estate. The son had a life insurance policy, and his son had 2 children, so he had to handle the life insurance policy. And he went to Loudoun County. Well, Loudoun County told him, when he lived in a halfway house, where was his last residence? So before he came to this halfway house, he lived there 2 years in Loudoun County. He said he lived in Prince William County. Went to the Prince William County clerk. Prince William County said, where did he live? Well, he's living in this halfway house in Loudoun County. And they said, well, how long has he been there? 2 years? Well, he's got to go to Loudoun County. He said, well, Loudoun County told me to come here. So he called me up, said, look, I don't know what to do. He died in Winchester. I said, well, just come on up here. And I handled the estate. I mean, at some point, somebody had to do it, and here we were tossing him back and forth across the state. And again, here he was having to deal with the loss of his son, and all he wanted to do was get access to this really life insurance policy that would help pay for the funeral bill and then have something left for the 2 young kids. And at that point, and one of the criteria, if it gets down to it, it's where he died. So I legally could have recorded it, and partly because no one else wanted it. And so there's a situation. Some lady over here had a question, or somebody, about co-executors, if it's wise to do it. Sometimes it's not bad to have a co-executor. And I'll give you, because it will eliminate some of the paperwork that a person will do. If you name, let's say, all your children in the will, let's say your spouse is deceased, your will says, I leave everything to my 3 children, and you name all 3 children as your executor. When they qualify, if there's an estate, you will have to file a document that shows what your assets are, called an inventory. But then, because the three are the named beneficiaries and also serve as the executors, you won't have to file a final settlement or a statement that says where all of it went. They can file this document that just says, we qualified, we're the sole beneficiaries named under the will, we all are personal representatives, 6 months have passed since we qualified, we say all the debts have been paid, and we're going to file this document saying as our final statement of accounting for this estate. And it does make it a little easier for them. So there would be some cases where it might be a benefit to name the one thing too with the naming the executors, and somebody had mentioned sometimes you have to go to the bank and they'll require both people to be there. Some lawyers are starting to put this in the will, that and this is where you have people who come to a lawyer, want a will, and they start making demands upon the lawyer. Well, I want all three of my children to be named as executor. Okay, where your three children live. One lives in Winchester, one lives in Frederick County, and the other lives in the jungles of Thailand, and we only have communication with him once a month when he comes in. You're there, well, why do you want that? Well, we want that. Okay, you want that. And this is a true story. So in the will, the guy named all three as executors, any of which who may act independently. Now, that sometimes can help a bank if they have that in a will. They'll go with that sometimes. But think about it, and that again goes back. Think about when you do a will. You want to make it. Some people may intentionally want to make it harder for the executor or their children. You know, if their children have caused them a lot of pain, this is your last chance. You can get back at them. You can say, okay, yeah, you think it was easy raising you? I'm going to have the last. And sometimes they, unintentionally or intentionally do make it difficult for the people. But that's one way you can avoid that. Any other questions?
If someone comes to you with a will written on a legal pad that Granddaddy Jack left, and it's been witnessed by two people, and has a notary still on it, can you probate this?
Yes. You can write a will on a napkin. I've had a napkin taken in as a will. And I wouldn't advise it, but that happens. Again, I think as Josh indicated here, when you write this will, you want to have some, what they call testamentary intent, your intent that this is going to be your last will and testament, how you want your assets disposed of. And I think, 21? You have to be over 18 to write a will, over 18 to write a will of sound mind. And depending it now, here's the thing when you say a notary, and here's where, state of Virginia has a law that allows you to, and this never used to be the case, where if you have it notarized and certain language is put in there, it's called a self-proving affidavit, you don't have to get the witnesses. Now here's where the trouble becomes. Somebody writes their own will and two witnesses, and it's notarized, but it doesn't have the self-proving language. Now we have to find the two witnesses. Now here's the problem. Had one last month. Will was written in 1971. Had three witnesses. Had a notary just said subscribed and sworn before me. That's all. And that didn't have the self-proving. Well, it wasn't self-proving at that time anyway. They had witnesses in 1971. Written in another state. The executor had no clue who these witnesses were. Now, there's other alternatives how you can get around that to get it put on the record, but at that time I couldn't record it because I couldn't get the witnesses. There were no witnesses available. Now, the way you can record that, but this in this case is probably difficult, if I could have found two people who could have come in there under oath and said, yep, that's the handwriting of the witnesses, and proved the handwriting of the witnesses, I could have admitted it to record. But this was so many years ago, they didn't know the witnesses, wouldn't have known who to call in.
I guess my question is more of a clarification of the definition of a witness. Are they witnessing the contents of the will or just your signature?
Generally, they're not, don't care too much about the will. They're just saying that the testator has asked me to be here, and at his request, I'm here with these other witnesses, and I've witnessed him signing this document which he is saying is his intending to be his last will and testament. And I'm here with these other witnesses, and we're all here. We've seen him sign it, and that's what a witness is. Now, you got to be careful about who sometimes your witnesses are.
Just to add on to that, they're not witnessing the contents of the will. They are not there to say this is what Bobby Sue wanted. They're there to say two things. One is, and Bobby Sue, when she signed it, she was sound mind and competence. So she wasn't crazy, she wasn't drunk, and she was over 18. And then two, she actually signed it. I saw her. I watched her sign it. That was her signature. And we have a little procedure we go through, and we have the witnesses go through to make sure, and we do the same thing each time. So if it ever comes up and there's ever a question, then yes, the witnesses sat there. They all saw this person sign it. They all made a judgment on their own that that person was of sound mind and judgment. So I think that's, yeah.
My understanding of a notary public is that they are witnessing the signature of the person. So if you verifying the signature, yeah. So how can the witnesses, unless a notary public is there at the same time, witness everything?
The notary public is a different procedure. So when you notarize something, you're right. You're appearing in front of someone who has a notary certificate, which you get from Terry as well. And that notary looks, hopefully, either they know you or they look at a driver's license or some other indication, say, this person appeared before me and signed it. The witnesses are there to say sound mind and judgment. So the notary doesn't, when you go before a notary, they don't say, you had anything to drink today, sir? How old are you? Any of that stuff. The witnesses are supposed to make a judgment about whether you're of sound mind when you actually sign the will. And again, this goes back to why we talked about before, why there's so many darn requirements to these things. And one of them is because we want to make sure when we have this document, and when you give it to Terry, we want to make sure that when somebody signed that, they really intended to do it. And they were in their right mind, and this is what they really intended. And so we have these two witnesses, independent witnesses, and I think Terry was going to talk about how you get into trouble with having somebody who's not independent witness a will. You have two independent witnesses, and they both are swearing, saying, yes, I sign it, I witnessed that you were of sound mind, and you did sign this document. So that's the difference between a notary and the witnesses. And it gets, honestly, we talk about self-proving affidavits and other things. It gets complicated very quickly. But if you do it right, and it's a complicated process, but if you do it right, it's very easy. And so that's why I think both Terry and I recommend that you do go see an attorney and make sure it's done right, so it's a smooth, easy process. And we had one where I worked with Terry, and I had to go hunt down some witnesses. And fortunately, I was able to find mine. But yeah, trying to find witnesses in another state, that's a that's a problem.
On the subject of witnesses, can the witness be the executor?
One of the things about the witnesses, and what I was going to say, and we don't have it too often, but sometimes people write their own will, called a holographic will, if you write your own will. And that's okay. Sometimes I jokingly tell people, they want to know about, should I have a will? I say, yeah, just write your own will and put in there, I, Terry Whittle, sound mind, over the age of 18, leave nothing to no one because I spent it all. Because that way everybody's going to be mad at you. But as long as you write it in your own handwriting, sign it, And if you didn't have any witnesses who witnessed the holographic will, I would say you need to find 2 people, disinterested witnesses, to prove this will. Now, disinterested is defined in the code, and basically for you is if you wrote a will like that and said, I leave everything to my next door neighbor, Mabel, and Mabel's husband comes in to prove the will, I probably wouldn't accept him as a disinterested witness because Mabel's going to get it all. I'd want to find somebody else who would be familiar with her handwriting, who would be able to say, yeah, I knew her, and I knew her at the time when she wrote this, and she was of sound mind, and that's her handwriting, that's her signature. And we don't see them very often. We used to see them quite often, and usually we'd go to a bank. Somebody at the bank would recognize you could always get a teller or somebody who would do that.
The witnesses' signatures, when you probate the will, do you verify signatures each and every time, or just wills that are in question?
No.
And what are those circumstances?
Most wills
in
have
general?
this now that are written, and I forget when this law changed, probably in the 70s. But it used to be you had to call in the witnesses, but they have this language that allows for the will to be proven on its face, called a self-proving affidavit. And it's basically states that the witnesses were there at the request of the decedent. They were present, saw her sign it, that's her signature, and they will say that in front of the notary.
Okay.
And sign it.
And
Now,
the witnesses don't have to be alive necessarily?
No.
Okay.
Well, once you have that self-proving affidavit, which majority of wills, fortunately, that I see come through are like that. The ones that don't have that sometimes are these wills from Staples. And anybody at work or have an interest in Staples, I've used them, and it's very, but LegalZoom.com, they get them, and the problem with that is not that they, on their face, are going to be a problem, but in completing them, it becomes a problem. And like I've tried to tell many people, and I have a lot of people come in, I want to write a will, can you give me some advice on it? And the other day I had some older gentleman came in one note, said, Mr. Whittle, can you give me the name of a good, cheap lawyer who I can contact to write a will? And I had to just tell her, ma'am, even the bad ones are expensive. So the one thing they get worried, and I made it a policy in my office, any will that is done by a form, I won't notarize it for somebody. And the reason I don't want to do it, not because I don't want to serve the community is because I don't want to be a party to something I'm not sure is legal. Because I don't want that person to come back and say, well, the clerk of the court notarized it. It's got to be legal. Why would he notarize something that wasn't legal? And I'm not going to be a party to that. And I advise them, you go to a lawyer or find somebody else but I always tell them, you might want to have a lawyer look at this. And the only story I have to say about that, one time, many years ago, I told somebody that. And several years after that, their spouse died. They came in and had a will done by a lawyer. And they relayed the story to me. They said, I was going to do it myself, but I went to this lawyer, and he really helped me out and didn't have to do anything. All you had to do was record the will. Didn't have to qualify or anything, but because he went to a lawyer, it saved him a lot of time, a lot of heartache, and less pain, especially at the time when you're dealing with the loss of a spouse.
The timeline for recording a will?
There's no timeline. Sometimes wills are recorded years after the date of death. Give you an example. When several years ago, I'd say over a decade or so, when Blue Cross Blue Shield merged with Anthem, a lot of people got stock, got a check for stock, and it was made payable to a deceased spouse. And, of course, they get the check made payable to Josh Hummer. Josh died 10 years ago. They go to the bank. I need to deposit this. This is a check written. And what does the bank say? You need to go see the clerk. You need to get a certificate of qualification. Oh, my goodness. Oh, my. Got to go through all that auto. And so at that point, maybe they recorded the will at that time, but they may have qualified, wouldn't necessarily had to qualify to get that taken care of, but that's happened. And sometimes people find the will many years after the date of death. And a question related to that question, do you have to record a will? No. There's no law that compels you to record it. Josh indicated that sometimes the court has the power to compel you to produce a will. And this, I've had this happen where a person dies, family problems, one sibling has the will, other sibling knows that there's an estate to administer, the other sibling doesn't want to put the will to record. And for whatever reason, I've had where the court has issued a summons to have that one who has the will compelled that person to produce the will so the estate could be administered. But that's a good question. The only thing I do say sometimes, and I do tell people, and this is, here's the question when I tell them they don't have to record it. Well, why do I need a will? I was at Westminster, Canterbury years ago, and I heard this clerk tell me, and this lawyer say it's a good thing to have a will. Now you're telling me I don't need to record it. Usually if I tell them not to record it, I always tell them put it somewhere where somebody knows where it's at just in case you need to record it. And the reason why you wouldn't necessarily record it, let's say you've gone through an estate planning, person dies, all the assets have passed outside of the estate, there's no reason to record it. And it isn't that wouldn't be that expensive, save you maybe $50, $60, but and sometimes I do say, well, it's a good idea to record it, but you don't have to. And when I tell people they're going to save money, they usually, okay, I think I'll keep it. Any other questions?
And Terry, just one other quick thing on that. You tell them to save it because they may find out that there's that check out there for $100,000, and all of a sudden they want to get that. And if they tore up the will or shredded it, then it's going to be more difficult. But if they still have the will, then they can go ahead. And that actually happened to my grandmother. She forgot to transfer one of her, I think it was like a $10,000 or $20,000 account. She forgot to put it in a trust that she had created. We talked about trust earlier. And so she did have to go through. She wouldn't have had to go through probate, wouldn't have had to use the will otherwise. But to get that last $20,000, she wanted to do it.
And last thing I'll leave you with, we talk about wills being in the issue of probate sometimes being complicated. Virginia is one of the more user-friendly courts or states as far as probate. Generally, most of the states you don't need have a lawyer to get involved with. You can have the executor can handle it. But going back to a question Josh answered, make sure you have confidence in the person who's going to handle your estate. If you name someone who's been convicted of a felony of embezzlement, that person may not be the one you want to be handling money. If someone has a lot of unpaid judgments where they owe the hospital money, have been owed landlord's money, owed doctor's money, and have judgments against them, that person might not be the person you want handling your money. And sometimes a lawyer, you got to be careful. Lawyer, if a lawyer's been disbarred because they've misused trust funds, I don't think you want that lawyer to be handling your estate. Now, those are all questions we ask. It's not something that it doesn't disqualify that person. But you might want to consider that. But in Virginia, it's pretty easy to do it. You don't need a lawyer for most part to, once you get to that point, you need a lawyer to get the will done, I would suggest strongly. In some states, you can't even walk into the probate court without a lawyer. We call those lawyer relief bills. And but Virginia is probably one of the user-friendly states in the country in handling probate, if that's any consolation to you. So if any of y'all are worried about where to go in Winchester, Frederick County, don't worry right now. Don't go back to your rooms or wherever and try to figure out, do I live in the city or county? And don't tell your executor, just go down to the courthouse. Somebody will handle it and take care of it for you. Appreciate all your questions, and I'll turn it back to Josh.
Thanks, Terry. Let's give Terry a round of applause for coming out here and speaking to us today. All right, I'm going to turn things back over to Rhoda for some final announcements, and then we'll be finished.
That was just excellent, Terry. Thank you very much for all that information, and Josh also. Okay, the last time that we were all here together, we talked about File for Life. I hope all of you who were here before picked up one of these, and that you went home and that you put all the documentation in it that it needs and put it on your refrigerator. If you didn't do it last time, please do it this time. Put in it all your contacts, emergency contacts, your list of medicines, all that type of information. It's the most valuable thing to have in your house on your refrigerator door. And don't forget to write down anything that you want to have discussed in the future. And don't forget the website, winchesterpolice.org. winchesterpolice.org. Go there, click on Community, and then click on the Winchester Frederick County TRIAD, and you'll see all three of these presentations. And please tell your friends, let them access it too. We want to keep on having this type of educational forum where we can all learn for ourselves and for our grown children, for those and even grandchildren, because even though we're concerned about things for ourselves, I know we all think about them and what they need for their futures too. So consider that as you're thinking of topics. And please, there are some things left over there. Please help yourselves. And if you have any more questions, if not, we'll see you at the next sessions. Thank you.